great pleasure for me to be with you and to bring a number of my staff members with me who I wanted to acknowledge. I know we're going to talk in some detail about Proposition 19, which is on a lot of your minds, and I want to acknowledge Lisa Lucero, who's a principal appraiser with our office, and she is one of my in-house experts on Proposition 19. We've got Robert Duarte, our Chief of Public Affairs, Steve Whitmore, our Public Information Officer, and Aldo Macias Ariano, who is a Special Assistant. He's operating the PowerPoint. Also wanted to give a shout out to my longtime friend, Mark Warnick. We served together as council members for many years, and Mark's been a very good friend, and I know he's a great leader in the city of Lomita. I'm glad you're able to find time in your busy schedule to join us, Mark, as well as I want to acknowledge Council Member Uphoff. I don't think we've had the chance to meet since you were elected, but glad to have you on board in local government. And I was glad to see that there's some representatives from legislative offices, including Senator Ben Allen. I was just on the phone with him before jumping on with all of you. So let me begin by telling you, I always like to tell people what it is that the assessor does, but I also like to emphasize what I do not do. And what I do not do is collect taxes. People always call me the tax assessor. There is actually no such thing as a tax assessor. In California, the concept of tax assessor is a conflation of two separate departments. I'm just the assessor, and I assess the value of property. There's another guy who collects taxes, and he has a really intuitive title. He's called the tax collector. Easy to determine who's the guy who's responsible for your bill, and that's not me. But I am one of, as assessor, I'm one of 3 county-wide elected officials. I'm probably the least known of the 3. Everybody knows the other 2 much better. That's the district attorney and the sheriff. As Heidi said, I administer the largest local property assessment agency in the United States. About half of our employees are real estate appraisers, and we're responsible for establishing the value for over 2.5 million real property parcels and business assessments annually, which last year were valued at about $1.8 trillion. As you can see on this, the chart on your screen, the assessor has a symbiotic relationship with other departments that each own a piece of the property tax system, primarily the auditor controller, as well as the treasurer tax collector. And the way the system works is that my office will get a copy of a deed from the registrar recorder or a building permit from the city. We then complete the assessment of value. The auditor controller is the one who tells you how much you owe. They determine the special assessments and the property taxes, but it's the treasurer tax collector that mails the bill and collects the payments. And last year, property tax revenues that begin with my office's valuation provided over $17 billion in revenue for vital public services, which I'm sure that the mayor and council member could tell you are needed now more than ever, because traditional sources of revenue from sales tax and tourism and even parking fines have declined due to COVID. What type of property is taxable? Well, the obvious is real property, which includes land and improvements. But I also am responsible for assessing what we call business personal property. And if you're a small businessman, which I know many of you are, you'll have to fill out the annual business property statement, which includes furniture, equipment, and machinery. And by the way, it also includes airplanes, both commercial and general aviation aircraft, mobile homes, boats, and even racehorses. My primary responsibility is the production of the annual assessment roll, which is kind of a fancy way of discussing the inventory of all taxable property in the county. The assessment roll is an important planning document for local government. They will use this in preparing their budgets in anticipation of property tax revenues, but it also serves as an important economic indicator, giving some insight as to the health of the real estate market. The 2019-2020 assessment roll grew at 5.97%, and that was the 10th consecutive year of property value growth in LA County. The biggest contributors to that growth were the transfers of real estate, that's the buying and selling of property, as well as new construction. Specifically, the city of Lomita was valued at more than $2.6 billion last year. Had a growth of 5.5%. That's just slightly less than the county average. There are 5,239 taxable parcels, including 3,800 single-family homes, 809 rental properties, and 581 commercial industrial parcels. I do want to emphasize, though, that those numbers do not reflect the impacts from COVID-19 on the real estate market. We are anticipating a significant impact, particularly on commercial properties, hotels, restaurants, and retail in particular, as well as a dramatic increase in assessment appeals and decline in value applications. But in spite of the economic distress caused by the COVID-19 pandemic, the real estate market in LA County has fared reasonably well, with the single-family median sales price currently at $763,000 for the county, compared to just $638,000 back in March of 2020, when the pandemic first accelerated. In the city of Lomita, median sales price is at $785,000, just a little bit ahead of the county median, and that's up from $730,000 in January of 2020. The large increase in the median sales price, however, is a bit of has some challenges in terms of gauging the overall economy. This increase is largely by sustained sales at the high end of the market. There's actually been large drops in the total number of volume, and properties at the lower end of the market are somewhat stagnant. Another issue that's I want to talk about that's particularly important for businesses, and I referenced that earlier, was the annual business property statement, also known bureaucratically as the 571L. So let me begin by explaining what business property statements are and why they're important. Separate from property taxes paid on real estate, businesses pay personal property taxes on equipment, machinery, furniture that has an aggregate value of $5,000 or more. If you have $100,000 or more in value of property, you are automatically required to fill out a business property statement. If you have between $5,000 and $100,000, you are required to fill out that statement if the assessor sends you a statement. A lot of people are confused as to how to complete these forms. They are pretty complicated. They're not complicated by design from my office. They're state forms. But we are going to be conducting a webinar on Monday, March the 15th, to help you complete these business property statements. You can reserve at our website at assessor.lacounty.gov, and Aldo will insert the flyer on the chat and email it to Heidi. So we'd appreciate your help in spreading the word to small businesses that might need a little of assistance. Now let me pivot to the big issue that a lot of you are concerned about, and that's Proposition 19. As you know, Prop 19 was narrowly adopted on a November 3rd ballot. It was a measure sponsored by the California Association of Realtors. And candidly, despite a number of the relative merits of Proposition 19, the truth is Prop 19 was rushed onto the ballot at the end of the legislative session, and we have identified numerous drafting errors and deficiencies that need to be fixed before I and the other 57 county assessors statewide can administer it properly. As you probably know, Prop 19 has two main components. The first deals with the portability of your property tax base. It allows homeowners who are 55 or older, the disabled, or victims of a natural disaster, such as the recent fires, to transfer their property tax base with them when they sell their home and purchase a new one. It allows eligible homeowners to transfer the assessed value and property tax bases anywhere within the state, unlike the previous law, which limited it to participating counties. It also allows you to transfer your base year assessed value to a more expensive home, as opposed to the previous law, which required that it be a home of equal or lesser value. It also increases from the previous law the number of times that assessment can be transferred from one occurrence to three. This component of the Prop 19 is effective as of April 1st. The other part, which is generally a lot more controversy, deals with the inheritance of the assessed value of family property. And it substantially changes the rules that applies to transfers between parents and children, and in some cases, grandparents and grandchildren. The former law, known as Proposition 58, allowed a parent to transfer their property to their children, as well as its assessed value without that property being reassessed. The children were not required to occupy the property. They were allowed to use it as a rental property. The previous law also allowed an additional $1 million in property to be transferred without being reassessed, property such as a rental home or a commercial property. Starting yesterday, Prop 19 has initiated these significant changes to the law, effectively repealing large portions of Proposition 58 and 193, otherwise known as the parent-to-child and grandparent-to-grandchild transfers. Prop 19 reduces the amount of assessed value in property tax benefits that you can pass along to your children. It requires that a number of elements be met in order to be eligible for Prop 19. One, the property that your children will inherit must be your primary residence. No other property now qualifies under the new law for property tax benefits. The home must become the primary residence of the child or grandchild within 1 year of transfer. And there is now a complicated formula that we need to apply depending on the value of the inherited home. If your home is under $1 million in value, your children can inherit the home and the tax base without a reassessment. However, once it's over $1 million, we have to employ an equation that will give you a new blended property tax rate, which will be an increase for your children. We've been doing the best we can do to inform the public about these changes, and it's having a big impact on a lot of financial planning decisions families across the state are considering. We did hold a webinar last month on Prop 19, which is on my website. We include estate planning attorneys and CPAs that help answer some of the questions that people are having about whether or not they should transfer their property to their children now or at a later date. Although since the measure went into effect yesterday, some of those decisions are now moot. There are enormous number of questions that we have with this measure. It needs a lot of legislative action to clarify the measure so that we can implement it. As of now, we do not have any legislation to help us clarify it. And there are literally dozens of questions that people are asking us where, as terrible as it sounds, the answer that we have is, I don't know. We're not policymakers. We don't have the ability to interpret the law. The law has to be specific for us to administer it, and we don't have those. So here's a perfect example of a question that we can't answer for you. Let's say that your mother and father own a home that you're going to inherit, but they both become ill and have to be transferred to a nursing home, and maybe they live there for 2 years before they pass. Well, under Prop 19, the home that you're going to inherit from your parents, for you to inherit it and to inherit the tax base, it must be your parents' primary residence. But if they're not living there because they're in a nursing home, it's no longer their primary residence. So when you inherit the property, you, as the bill is written, you would not be able to inherit the tax base because it is not the primary residence of your parents at that time. We don't think that was the intent of the language. However, that's what it says, and I don't have the authority to interpret what I think it should say. I have to enforce what the law actually says, absent clarification from the legislature. So there's a lot of questions, and a number of them are on the questions that were submitted in advance. So we'll get to those in just a minute. The last thing I want to talk about before I move to the Q&A session is a little tip on how to save a little bit of money on your property taxes. My office actually manages a number of programs to help taxpayers save money on property taxes. There's programs for seniors, for veterans, for the disabled, but the one I wanted to talk about today is what's called the Homeowners Exemption. The Homeowners Exemption helps property owners save a little bit of money annually on their property taxes if you own your home and occupy that home as your principal place of residence as of January 1st. It reduces your assessed value by $7,000 for tax purposes, which will save you about $70 a year on your property taxes. I know it's not a lot, This was put into effect in 1970 and it hasn't been adjusted. However, about 1/3 of all homeowners in LA County do not apply for the homeowners exemption, leaving about $30 million in unredeemed savings. And the primary reason they don't apply is because they don't know about it. We estimate that about 1/3 of all homeowners who qualify for this in the city of Lomita do not claim this benefit. And maybe the mayor and council member would do us a little, help us do a little bit of lifting in Lomita by spreading the word. And maybe there's people may be living on fixed incomes, they may not be working right now, and $70 may not be a lot, but it's when you're struggling, it's helpful to save money anywhere you can. Applications received, but from January 1st to February 15th, we'll get the full value of the exemption this year. Those received after February 15th will be eligible for 80%. You can get the form on my website, which is at assessor.lacounty.gov. Contact information and the link is in the chat bar as well. But I want to thank you, Heidi, for the opportunity to speak to the chamber today. Thank you all for taking the time to listen, and I'm happy to answer questions for you at this time.
Wonderful. Thank you so much, Jeff. We so appreciate that. And I think, some clarity to how these kinds of decisions are made and possibly voted on is really important for people to understand. So I can appreciate the challenging position that your office has. But we have a lot of great questions. And I think you all are going to get something out of each one of them. So if you're ready for the Q&A, I'm going to start with my first one. So the first question we have is, if the property is transferred from parent trust to child trust, will there be a new assessment on the property?
Okay, I'm going to do the best to answer your questions. I did want to let you know I have Lisa Lucero, who is a career appraiser, and if your questions are too hard, I'm going to turn them over to her. But the as it relates to this one, as long as the it will not be reassessed as long as the child inheriting the property files for the homeowner's exemption within 1 year of inheriting the property. Homeowners should also be aware that it is the parent to child exclusion that prevents the reassessment, not the trust. The trust does not take care of the ministerial things that you are obligated to do to inherit property. This is actually if I could speak briefly on a point that gets a lot of people in trouble. Folks know that you can inherit property without being reassessed, but it requires you to do certain things proactively. The first thing is, if you're inheriting it upon the death of a parent, you must notify the assessor within 150 days by filing what's called a change in ownership, death of real property owner form with us. That's what tells us that there has been a change in ownership. Secondly, you have to file the Prop 19 exclusion. And now you also have to make sure you file for the homeowner's exemption. One of the challenges that Prop 19 will have in this scenario is that, I don't know what the percentage is, but I would say that 80% of the people don't know they need to do these things. And we are constantly getting public service calls from people after they get a supplemental tax bill asking why they were reassessed. And under the current, the now previous law, you could sometimes do this up to a year or two, and sometimes 3 years or more. And there were certain adjustments that we could make, at least prospectively, to apply that exclusion. Under Prop 19, there is no wiggle room. You have to do it within 12 months. And it's oftentimes difficult when there's a death in the family. The last thing you're thinking about is filing forms and figuring out what needs to happen at the assessor's office. And you may not discover that there may be a reassessment until it's too late. That 12 months is hard and fast. And we're not going to have any wiggle room at this side in the assessor's office like we did under the previous law. So this is really important information to know.
Great, thank you. And get your estate planning in order, right? So when the time does come, you kind of have those things in mind. Okay, second question is, what will the net change in inheritance tax be now versus under the new legislation? And there was a question in terms of why this would be supportive or supported. Kind of seems like a negative. So again, what will the net change in inheritance tax be now versus under the new legislation?
So this kind of moves into this equation, and this is where I'm going to rely on Lisa to help walk us through how the taxes will change under the new scenario. Essentially, as I said before, if the value of the property is under $1 million, you can inherit the property and the property tax base with no change. But if the property is more expensive, Lisa, can you kind of walk us through that scenario? You need to unmute yourself. Lisa?
Thank you. Sorry about that.
Sure.
To calculate the new assessed value of a property, you need to know two things. You need to know the excludable limit and the fair market value of the property. The excludable limit is the sum of the factored base value or current assessed value of the property plus $1 million. If the fair market value of the home exceeds this excludable limit, then partial relief is available. So the amount exceeding the excludable limit will be added to the current assessed value to arrive at the new assessed value. So for example, if the current assessed value is $300,000 and the fair market value of the property is $1.5 million, we need to determine the excludable limit. So the current assessed value plus $1 million, as in my example, was $300,000 was the current assessed value. We add $1 million, that's $1.3 million. That's the amount that would be excludable. That's the amount that you compare to the fair market value to see if it's excluded. So if your fair market value of your family home is less than 1.3 million, then there's no change in the assessed value. But in my example, I said the fair market value was 1.5 million. So you have to determine the difference between the excludable limit and the fair market value. Fair market value is 1.5 million, excludable limit 1.3 million. The difference is 200,000. That's the amount that's going to be added to the current assessed value to arrive at your new base value, which is 500,000 in my example. And as Assessor Prang indicated, it is not automatic. You do have to apply, and the transferee would have to move into the home, file a homeowner's exemption or disabled veterans exemption within 1 year of the transfer.
Thank you, Lisa. Another part of that question was why would I support this when it has negative impacts? I did not support the measure. I actually didn't weigh in for or against it, but this measure is going to have. This is one of the elements which will have a negative impact on a lot of working people, middle income people who have modest amounts of real estate investments. It will create an increase. If depending on how much property you have, even modest amounts of investment will result in increase in taxation for your children and or your grandchildren that did not exist previously under the previous law. I actually believe this was a mistake in this measure, and I actually think that the legislature should go back and revert to the previous law, which allowed, particularly for working people, for middle income people, where there's not a lot of generational wealth, and you finally get to a point where you have a few things that you want to leave to your kids. The increase in taxation in many cases will make it difficult for them to afford to keep that property. That's that's my political opinion, but this measure was voted on by the people of California. It was not imposed by the government, but I don't think people were really very. The part that was going to affect working people was not part of the campaign to sell this measure, and it was. It's just now revealing itself now that the measure is going into effect.
Thank you, Lisa and Jeff, for answering that. And it's so important for us as voters to read and study up on what we're actually voting for before circling in that bubble. So it's a very valid point. So the next question we have from our participants is, what are the rules regarding transfer of Prop 13 basis when buying and selling, or selling and buying?
So under Proposition 19, the portability of your property tax base, that element of Prop 19 goes into effect on April 1st. And eligible property owners who are 55 or older or disabled may transfer their Proposition 13 tax base up to 3 times when they sell their principal residence and buy a new principal residence. And that new residence can be of any value. Additionally, homeowners affected by natural disasters such as the fires that we've experienced may also transfer their base year of their principal residence to a new principal residence, although that was also negatively impacted. Right now, under previous law, if a homeowner impacted by a fire had 5 years to transfer their base, Prop 19 reduces that to 2 years. Probably an unreasonable amount because, for example, right now, those folks who were affected by the fires 2 years ago may not have been able to do anything in the course of COVID last year. 2 years is not really a good period of time to build a replacement home. Just getting through the planning and building process may take a year or so. So this is going to put some hardship on people who are victims of natural disasters.
Okay. This kind of relates to my situation without getting too personal. Not my question, but I appreciate it, whoever asked this. If 2 people not married own a property joint tenancy, does the tax go up when one of them dies?
So the short answer is yes. If one individual acquires property, then adds another individual on the title as a joint tenant, and the first one dies first, the property will be reassessed 100%. Absent an applicable exclusion. But if the second party dies first, the property will not be reassessed. If they acquire the property as joint tenants, then upon the death of the first or the second, whichever occurs first, there will be a 50% reassessment absent an applicable exclusion. Does that make sense?
Fairly quick response.
Yeah, it's a little bit confusing, and I don't know if Lisa, if there's an easier way to convey that in real person terms, or is that pretty much the basics?
But I just want to let everybody.
Yes.
Sorry, Lisa. I just want to let everybody know as well that we have contact information to reach out to the assessor's office and also links to his website as well. So I know a lot of these are very specific to your situation. So they've offered that resource, which is very generous as well. I'm going to continue on with the questioning because I want to make sure we get to all these for you. The next question is, I'm due to inherit my parents' home through a living trust. The home's located in Riverside County. My husband's due to inherit his mother's home through a living trust. Her home is in LA County. My husband and I are both over the age of 55. Can you please tell us how the new proposition will affect property taxes on a home that is inherited? And what can we do to avoid higher property taxes with the new proposition? So 2 different counties, both inheriting property.
So this is one of the questions that we have questions ourselves. This is where we need legislation to be enacted to provide us a little bit more guidance. Under Prop 19, a child that inherits property from their parent, it must be the parent's primary residence. It must become your primary residence, and you must file within 1 year, and you must file a homeowners exemption claim, as well as the Prop 19 parent-to-child exclusion. The challenge is if you have 2 homes, one is yours and one is your spouse's. Because one of the requirements is that you occupy the property. One of the properties, you will not be able to inherit that property tax base. You will have to, that will be reassessed at market value at the time that you inherit it. So if your mother bought her home in Riverside in 1980, it valued at $25,000, and now it's worth $800,000. You're going to see a pretty hefty increase in property taxes if that's not the home you choose to live in. under the previous law, you would have been able to inherit both of them as well as the tax base.
Okay. This might be a little bit of a recap from what you covered earlier, Jeff, but I'm going to give you two questions here. How Prop 19 affects children of homeowners and how it will affect seniors.
So it affects the children of homeowners by requiring certain mandates that didn't exist before. It only allows you to inherit the primary residence of your parents. If the parents owned other property, you can inherit it, but you'll be reassessed at market value. And depending on how valuable that property is, you may end up with a bigger tax bill. For seniors, it's more beneficial. If you're a senior, it means that if you bought your home in 1990 for $100,000, then you can move 3 more times and take that $100,000 tax basis with you, and you can move anywhere within the state. And including purchasing a home that's more expensive. If you purchase a home that's more expensive, you will get an adjustment to your property taxes. It will be less than the market value tax, but it will be more than what you're paying at your previous residence. So it does have some advantages for seniors.
How will Prop 19 affect mobile homeowners?
It won't, because mobile homes are considered personal property, and they're not. At least at this point, we don't believe that they're dealt with by Proposition 19. However, that is one of the areas that we're waiting for clarification from the legislature. They may determine that they may want to pass along some benefits to mobile homeowners, but at this point, the measure is very unclear about that, and we don't have any guidance.
This is more specific, I think, to personal family needs planning. So I'm not sure that you can actually address that, but I'm sure that your office can help provide information on the proposition itself when that person considers any of their personal family needs. Is that correct?
We're not allowed to give legal advice, but there are a lot of things that need to go into consideration when it comes to estate planning and transferring or inheriting property. You need to consider things that are beyond just the property taxes. You should consider estate taxes, gift taxes, capital gains taxes. It's always we can tell you what the different rules are that will help to guide you, but it's always helpful to rely on experts in the field to help you with legal advice.
Great, good clarification. Okay, a couple more questions. And for those of you, as we work through these last couple, if we haven't asked a specific question, I would ask that you put it in the chat. And I know we have one question that we'll get to in terms of some of the forms you referenced, but the next question we have here is, so Prop 19 required inherited homes as primary residences to be reassessed by the California Home Index after 2023. How will that work? I understand that Prop 19 requires inherited homes, which are primary residences, to be subject to that index for reassessments after 2023. Will your office implement that? And does that index fluctuate a lot? It doesn't seem fair to children who lose their parents, live in the same house, then get hit with property tax increases through no fault of their own. That provision, as you said earlier, was not publicized much, and I think most voters missed it. So again, a little redundant here, but certainly kind of hammers home all of that.
Everybody missed that, and if I may be so bold, it was deliberate. One of the things I've learned in trying to push the legislation to the enabling legislation to administer this measure was that there was a deliberate trade-off made to give more benefits to seniors in order to help them move more often, and the way they paid for that was by limiting the inheritance benefits. And when they talked about inheritance benefits, they really focused on super rich people. Everybody may recall the story in the LA Times, the family of the late actor Lloyd Bridges and his kids inheriting their Malibu property, paying very, very low taxes, but leasing the property out for $16,000 a month. And a lot of folks thought that family inheritance law was intended to keep cherished family property in the family, not to provide a tax-free economic boon for the 1%. But the truth is it's working people, middle income people with modest holdings who are being penalized in this measure. And apparently that was deliberate, and it was not part of the campaign because it would not have been a good selling point. But speaking that question specifically, per the language of Prop 19, the $1 million exclusion amount for transfers between a parent and a child, or in some cases grandparents and grandchildren, it'll be adjusted annually by the State Board of Equalization starting in 2023. The assessor will comply based on any of the rules that the legislature adopts and the Board of Equalization adopts accordingly. But that was part of the language in Prop 19 that was required.
Okay. Another question that just came up recently was, does the proposition have any impact on commercial property taxes, and if there's any transfer between family owners there?
So no, the commercial property no longer qualifies for the exclusion. Under the previous law, it did up to, so if you inherit your parents' home, and let's say they had a strip mall, you could inherit the tax base of up to $1 million in value on that strip mall. Under the current law, you no longer can inherit that tax base. When you inherit that strip mall, it will be reassessed to market value, and you have to pay the full property tax. It does not deal with, same thing with LLCs, do not count. LLCs are a legal entity. They do not qualify for inheritance. It's just the primary residence, and if you do things properly, property that's in a trust.
Okay. And last but not least, we've got a couple little questions. I see Aldo answering some of those. Thank you, Aldo. Who should my clients contact if they have questions? CPA, tax professional, LA County assessor. I think we covered that already, but let's hammer it home.
So we do have in the chat room, I put in there my phone number and my email address. A lot of your questions are things that I personally probably won't be able to answer, but if you send them to me, I'll put them in the hands of somebody who can answer them for you. Aldo can put into the chat a link to our helpline on the website. But we know that a lot of people are going to have a lot of questions, particularly over the next couple of months on Prop 19, because we don't know how to enforce it. So if we're confused, we know you're going to be even more confused. But we want to do the best we can do to try to steer you in the right direction.
Okay, and I just want to address a couple comments. It looks like somebody may not have had such a great connection, but we're hanging in there at a pretty consistent pace with participants, so maybe it's an internet issue. This recording will be available. We will post it on the Chamber's website, lomitachamber.org, and certainly we'll make this accessible to the assessor's office as well. A couple more questions if you have a few more minutes, Jeff.
Sure.
Okay, let's see. One of the questions was, if we sell the inherited home within 1 year from inheriting, can it be assessed at the old value?
Lisa, do you
have? A change in ownership. A change in ownership. We assess property as of the date of change in ownership. So we would assess it at that point. You would be Prop 19 would be available if you met all the requirements, which would be moving into the home within a year, filing a homeowner's exemption, and filing a Prop 19 claim. You don't meet those requirements, it would be reassessed at market value at the date of change in ownership.
Okay, thank you, Lisa. Another question, if your parent passed prior to Prop 19, does it still apply?
So this is another point where we don't have great clarity. So if there's a transaction where they passed before Prop 19, but you purchase a home under Prop 19 after it goes into effect, we believe that we would apply the law that was in place at the time that part of the transaction took place. But it's very unclear from that's part of our legislative package where we're looking for guidance from the legislature.
I got two more here. Would putting your child on title before they pass keep the property from being assessed?
I believe that you would basically be doing a Prop 19 transfer. You don't have to be deceased in order to make that transfer. It has to be your primary residence. The child would have to move into the property within 1 year. They'd have to file for the homeowners exemption, and as long as they meet those conditions. But I guess the one question I have is that if you want to do it before your parents die, at a certain point you're going to have a roommate who's now your landlord.
Okay. The next question, if a person over age, they're coming in fast for yours. If a person over age 55 applies to transfer the base year value to a replacement dwelling with the intention to remodel and add an ADU to that replacement home, how much time do you have to finish the remodel before it's too late?
A couple of moving parts there. Lisa, you want to separate those for us?
Well, if you move, you have 2 years to find a replacement property. And any new construction needs to be done within the 2 years as well. Now, again, we'd have to, at that point in time, compare the market value of the original property and the market value of the replacement property. Anything, any value above the original property, when you buy your replacement property, is going to be added on. So as long as the AUD, the value of the AUD is less than, and the purchase of the replacement property, the sum of the two is less than the original property sales price, it should be covered under Prop 19. Anything above that would be valued at market value, or we would value that and assess that. And that would be added to the transferred base value.
Okay, thank you, Lisa. And Lomita Council Member Bill Uphoff has a question here. Welcome, Bill. Thanks for joining us. Any idea when we might receive clarification on the issues you noted from the state?
So we're in the middle of the legislative process. We have a multitude of lengthy, complex documents, and Councilman, I would be happy to provide you with a briefing as to where we are. I'm not sure that the working documents we have right now might be a bit of a mystery to you at this stage, but we could walk you through them and explain them if you'd like a little bit more detail. But we don't have anything as a retail sort of summary for the public, because it's a very fluid process at the moment.
I can appreciate that. Thank you, sir.
Sure.
Okay, another question coming in here. If the parent is a disabled veteran with service-connected disabilities, are they exempt from all of these new laws contained in Prop 19?
I don't know that. Lisa, do you have an answer to that question? I don't think we have it. I don't think it's been.
I don't believe they are exempt from this.
I'll give you an example of it.
There was no language. I'm sorry, Assessor Prang, go ahead.
I'll give you an example of a veteran related
There was no
issue.
language.
Go ahead. Go ahead, Lisa. Finish.
There was no language in ACA 11, which was the proposition language, that exempted disabled veterans.
There is let me give you a scenario though that I find to be very disconcerting about Prop 19. Let's say that you inherit your home from your mother when she passes, but you're active duty military, and then you get called to service, and you get sent to Afghanistan for 2 years. Well, under Prop 19, when you inherit that property, the law says you must continuously live there. So when you are sent to Afghanistan for 2 years, you're not continuously living there. So we would have to raise the property, the assessment, and therefore your property taxes to market value while you're away, because you're no longer meeting the terms according to the way that the measure is written. We don't believe that anybody would have intended to do that, but that's what the law says. And until we receive legislative clarification, I am constrained by what the law says, not what I think it should say. So there are just literally dozens of little pieces that are just like that that are going to cause problems for people.
Okay. Well, I think that does it for our questions. Thank you, Jeff, very much for your time, and to your team there at the assessor's office. And thank you, Lisa, for jumping in and clarifying these questions. Again, please reach out to the assessor's office, use the resources that have been made available to you. As we said, the recording will be available by tomorrow at the lomitachamber.org website. Apologize to the person having technical difficulties, but yes, the recording will be available to you. And I just want to say thank you once again, not only to Jeff and his team, but thank you, Mayor Warnick, for being here, as well as Councilmember Uphoff, all of our colleagues over at the Torrance Chamber, our neighbors, Senator Ben Allen's office, and Assemblymember Patrick O'Donnell's office. And if there's anybody that I missed, please forgive me, but really great turnout, and I thank you all for being here. Please visit our website if you'd like to see more chamber events that are open to the community and to support our businesses. We are having an event next week from Torrance Memorial. One of our doctors at the medical department will be talking about COVID, the vaccine, and providing an update. So we welcome you all to join us then. Once again, thank you, Jeff. Any final comments before we sign off?
Heidi, I want to thank you. Want to thank the mayor and the council member and all the good folks at the Lomita Chamber of Commerce for inviting us, and hope that you'll invite us back.
Definitely.